What is so wrong with the UGC guidelines that they had to be paused?
नए रूल रेगुलेशंस थे यूजीसी के, उनको स्टे कर दिया गया और 2012 के जो रूल्स हैं उनको दोबारा से लागू कर दिया है.
What is the clarity that Supreme Court has asked for, and what are the questions that have been raised around these guidelines, which is creating protests pan-India? Our constitution did not just promise equality, it also promised dignity, it also promised fraternity, and also a sense of belonging. Yet, even decades later, our Indian campuses continue to reflect society's deepest fault lines. And when UGC attempted to codify the equity guidelines in 2026, Supreme Court decided to pause and reflect on the deeper questions associated with it for clarity, so as to ensure there is no misuse and to ensure that the ideals of constitutions are fully fulfilled. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to discuss the Supreme Court's stay on UGC equity guidelines of 2026. Why did Supreme Court stay this? What are the reasons and questions that have been asked, and what exactly is the clarity and the constitutional provisions that we really need to look into before moving towards any such guidelines? So let us begin with understanding that what exactly has unfolded. So when we are talking about UGC guidelines which have been brought in for equity in 2026, these are for higher education institution and specially to address the equity, equality and opportunity. If you want to understand about this in detail, I have already covered it in a video, you can go and watch it. Today we will be focusing on why it went to Supreme Court. So the reason it went to Supreme Court, the main provision and the definition of caste discrimination that was given, that was only relevant for scheduled caste, scheduled tribe and OBC, and that led to protest across India, and especially the campuses which should be known for delivery of education, which should be known for opportunities, they become the background, they became the ground of this protest. So that is where Supreme Court had to intervene and reflect upon it, and it put UGC guidelines on pause. That means there has been a stay on UGC guidelines, and Supreme Court not just stayed these guidelines, the new set of rules, but also they have asked very relevant questions, and they have also highlighted that these UGC guidelines are vague, they are capable of misuse, and that is why they can be retorted in different ways, and they will not be not the one to serve the purpose when they are talking about promoting equality. Now this particular statement came from our CGI, that is Chief Justice Surikant and also Justice Joy Mala Bagchi. Now whenever we have at least 2 or 3 judges in Supreme Court or High Court, it is usually referred to as a divisional bench. So this particular bench has remarked, and we will be looking into this remark in detail. Now furthermore, adding to this, a very important thing that has been highlighted by Supreme Court, that these UGC guidelines are not just vague, they are prone to misuse, but they will lead to a very dangerous impact. And if actually UGC guidelines which are meant, they are there to address equality, they should be not on this particular format. And Supreme Court has not only asked for a reply from center, they have also told the Solicitor General, that is Tushar Mehta, that they must constitute a proper committee and they should include eminent jurists so as to address this whole issue of UGC regulation. And if actually the University Grants Commission, which is the monitoring institution, the regulatory of higher education institution, should want to bring such guidelines, then it should come from this particular committee, because such guidelines have a huge impact on the higher education culture, on the academia of the country, and it can have disastrous impacts if these guidelines are not right. They can actually go ahead and create more division rather than bringing equity, equality and opportunity. So Supreme Court has a very logical reason to press pause. That means they have stayed these guidelines as of now. Now in this very context, another thing that becomes very important is the fact that why did Supreme Court intervene? Why Supreme Court had to step into this situation? So as of now, Supreme Court had to intervene because there are certain things that were observed with the regulations. Now not only that these regulations were confusing, they were contradictory, but also there was a widespread protest and sentiment against it. So all of this with the certain things that court observed in the regulations brought this intervention. Now what did the court observe? Court observed that there are certain vague and overlapping definitions which are actually creating the friction. We will be talking about this in detail. When we are talking about the provision present in this equity guideline, they can be misused by authorities to target certain sections. For example, when we talk about the definition of caste discrimination, it only includes scheduled caste, it includes scheduled tribes and OBCs. What about most backward classes? How that will be addressed? So these are certain problems that are present there. Furthermore, there is a lot of confusion that how exactly there will be implementation. And another most important thing that has been highlighted, and that marks the point that why Supreme Court had to intervene, that it seems like that it might be violating some of the constitutional values. Now let us break this down in detail one by one, starting with understanding what was the core problem. Now the core problem here was definitions. So in this very equity guideline of 2026, there were two definitions that were given. First, caste based discrimination. Now this was defined as a discrimination only on caste grounds, and this was applicable, as I mentioned, only to three categories, that is scheduled caste, scheduled tribe and OBCs. Then there was another definition of discrimination, but this was not caste specific, this was general discrimination. Now this definition covered unfair treatment on other grounds including caste, be it religion, be it race, gender, place of birth or disability. Now when we are having two definitions here, first it creates confusion that which is the exact definition that needs to be followed. So court had a very simple doubt here, that if you gave one definition about discrimination and in that caste was covered, then why did UGC decide to give another caste based discrimination definition, and why and what extra protection this new definition is giving that this definition is not giving. So that was a very obvious doubt and confusion, that is there any provision that we are not able to understand, is there any undercurrent running, is there anything that is not on the papers that might have. So huge confusion, there was no clarity, and that is why Supreme Court raised their doubt in form of a question. Now based on this, Supreme Court had their first question, that why this separation? Supreme Court simply asked, why did you define caste based discrimination when you have the same process for both of the definition? There is no special safeguard for caste cases, and this raises a very important constitutional concern around Article 14. That law must not be arbitrary in nature, and if there is any separate classification, it should have a proper clear purpose, and it should also have a real legal benefit, which does not seem to be present as of now. So court has clearly said that we fear that this first definition that you have given, the extra definition, that is just symbolic in nature. It has no substance. It is symbolic in nature, it has no substance at all. And this is something that we do not expect of such an important regulatory organization in our country. So you need to clarify this, because this was the extra definition which has created the protests across the country, which has created the confusion. Now on this note, This was the first question that Supreme Court asked, and it had a very simple constitutional concern around Article 14 itself, that the law must not be arbitrary, because this is the article which prohibits states' arbitrary actions against the individuals. Now, on this very note, on the core problem itself that we discussed, Supreme Court raised another question that was about why most backward classes or extremely backward classes not included in this definition. If you went ahead and took the effort of defining caste-based discrimination, why are you just including these three broader categories? Why there is no mention of MBCs and EBCs? And court raised a very important concern again here. That was the fact that when we are talking about castes being vulnerable, groups being vulnerable, then these are the groups, MBCs and EBCs, which are most vulnerable. You have certainly ignored it, and you have also ignored the internal framework that exists within the caste, which also causes caste discrimination. So here, an important key term also emerges that you must note down here, is the fact that court is highlighting that you are working towards formal equality. It does not carry any features of substantive equality. That means what you are doing or is superficial, it's shallow. If you really want to address this, you have to include and not ignore the real problems such as the internal classification within the caste itself. Now, apart from this, another important question with a different provision has been asked by Supreme Court, which was related to Regulation 7D, which basically says there should be allocation, segregation and transparency for hostels, classrooms and mentorship groups. So, the three key terms have been used here: allocation, segregation and transparency. The problem with the term is segregation. Even if it is done transparently and the allocation is done properly, why there needs to be segregation of hostels, classrooms and mentorship groups when we are talking about equality, when we are talking about equal treatment? So, court has raised the concern here that even if you are doing it in a transparent way, does this not encourage segregation? And if segregation is being encouraged, how are we talking about equity and equality? And doesn't it promote separate but equal thinking? And if it does, then how? And with these questions, you have to understand that it not only violates Article 14, which talks about equality, it also violates Article 15, which talks about no discrimination, and also ideals of the preamble, which talk about fraternity and bonding and having a sense of belonging. Now, these are important questions because as I have been showing you that there are not only court's concerns that have been highlighted, but the constitutional provisions that are being violated, that are also being highlighted. Apart from that, there was another question that Supreme Court has raised, which is important when we are looking at these guidelines in deep, is the fact when we were looking at the earlier guidelines that were brought in by UGC back in 2012, it included, when we are talking about equity guidelines, it included ragging. But 2026, ragging has been removed from equity framework. Have we stopped hearing about ragging cases? Have we stopped hearing about harassment that is caused to new students, freshers because of ragging? Why all of a sudden UGC decided to take this away when they are trying to make the campuses more opportunistic, more equal? And court has clearly highlighted that it is ragging that not only causes trauma, it also leads to social exclusion that equity guidelines are trying to address, and it also leads to loss of dignity. So, the dignity that Constitution is promising are not priority of these guidelines. And if this is removed, it reduces protection and it also violates our Article 21. Which is not just right to life, but which is right to dignity as well. Now, these are certain important questions that Supreme Court has placed in front of us with the proper provisions that have been highlighted and staying these guidelines. What are your thoughts on this, especially when the Supreme Court has taken a very clear neutral stance so as to ensure that there is further no more division on the UGC guidelines? Let me know your thoughts in the comment section. That was all from my side. I'll be leaving you with way forward, because as of now we need clear definitions which do not bring in the misuse but bring in clarity, bring in cohesion, and also the equality and fraternity that we are talking about. We need explicit inclusion of ragging, protection of MBCs and EBCs as well, and replacing segregation with something that actually means inclusive and intends inclusive. Because when we are preaching equity without any clarity, it will do nothing but undermine equality and also fraternity that we are seeing in this particular scenario. Now, that was all from my side. Thank you so much.